Welcome to Divorce at Altitude, a podcast on Colorado family law. I'm Ryan Kalamaya. Each week, along with my business partner and co host, Amy Goscha, or an expert, we discuss a particular topic related to divorce or co parenting in Colorado. In addition, we have created a short series of lessons that will take you through the legal process of divorce and answer your questions, from simple to complex. Divorce isn't easy. The end of a marriage, especially when children are involved, brings a great deal of loss and change. We hope these practical tips and insights will help you on your journey to a new and better life. This episode is focused on parenting, children, and divorce. And it's done from a 30,000-foot perspective. In future episodes, we'll dig into specific issues as they relate to children in a divorce. Now, everyone wants to know, how does a court determine child custody? We frequently get calls wanting to hire the best child custody lawyer, and they're worried about the other side going for full custody. And the first thing that we do is we explain that there is no such term as child custody in Colorado in terms of divorce. The what used to be known as legal custody has been changed into decision making, and what used to be known as physical custody has been changed into parenting time. Well, why did Colorado and the law change, and why do we not use the term custody? Well, simply put, custody suggests ownership, and we don't own our kids, we parent them. So, what do the courts consider when it comes to parenting time? Well, the first thing that the court does is going to look at the statute, and it's characterized as the best interests of the children. And the statute is 1410-124, and it lays out for the court various factors that the court has to consider. And by extension, divorce lawyers and child family investigators and parenting evaluators, which we'll get into, they all reference these various factors. So, what are they? Well, the first is the wishes of the parents. If one parent does not want as much parenting time, the court is going to take that into consideration, certainly. The second factor is the wishes of the children. And up until 18, there is no statute that says that when a child turns 12 or 15, that they get to decide. We get calls asking about that fairly frequently, but generally speaking, up until the child turns 18 or otherwise becomes emancipated, the children's wishes are a factor. So if the child is 4 years old, like my son is right now, that's going to be different and have a different weight put on it by the court compared to a 14-year-old. But it's not dispositive, and it doesn't necessarily drive or decide the case. It's just one factor that the court's going to take into consideration. Another factor is the child's interaction with other family members, such as siblings or grandparents. The fourth factor is the child's adjustment to his or her home or school. The fifth factor is the physical and mental health of the child and the parties. So the court's going to take into consideration whether or not the child has special needs or some sort of physical issue or other thing that might be relevant. Similarly, if a parent has a mental health disorder or some sort of substance abuse issue that relates to parenting time or can impact their parenting, the court's going to take that into consideration. The ability of the parties to encourage the sharing of love, affection, and contact between the children and the other party is also a factor, as is whether the past involvement of the parties with the child reflects a system of values, time commitment, and mutual support. Importantly, the distance between the parents' homes as it relates to practical considerations for parenting time is another factor. And that means that if you live in Longmont and the other party lives in Denver, that can really matter for parenting time. And as we'll get into in a future episode on parental relocation, if a parent lives in Aspen and the other party wants to move to, let's say, New York City, that's really going to change the practical considerations as it relates to parenting time. Finally, and oftentimes most importantly for the court, is the factor, and that is the ability of each parent to place the children's needs ahead of their own. Now, when the court goes through that analysis for parenting time, there's going to be what's called a parenting schedule, and there can be a different parenting schedule during the school year as compared to the summer. Similarly, the holidays are also going to be a factor when it comes to parenting time. Taking all of those factors that I just went into consideration. Now, what about decision making? Decision making is going to be whether the kids go to private school or public school and what public school they go to, whether they play football or soccer or they participate in some sort of extracurricular activity. Those are big picture and what are called major decisions. And it would be for health, religion, extracurricular, and education. Those are the primary factors. So it's not whether or not the kids get to watch TV at night before they go to bed. Those are decisions that are made by the parent during their parenting time. But when it comes to decision making, courts are instructed to consider all relevant factors, and they also are asked to consider, in addition to the parenting time factors, a couple other factors, including evidence that the parties can cooperate and make decisions together. So, if there's been a history of conflict or one parent making a decision over the other, that can relate and be relevant for deciding decision making. So can evidence that there is a past pattern of involvement of the parties with the child that reflects a system of values, time commitment, and mutual support that would indicate an ability as mutual decision makers to provide a positive and nourishing relationship with the child. So what that means is that if you've been able to make decisions, you might fight like cats and dogs over various other issues in parenting. But if you guys are generally in alignment on, let's say, what school they go to, then that might be a factor when the court considers decision making. Finally, evidence that a particular decision will promote more frequent or continuing contact between the child and each of the parties is also a factor. As we'll get into in different episodes, domestic violence can matter for parenting time as well as decision making. But again, this is more intended to be a broad stroke on how parenting time this is decided. Ultimately, if the court is asked to make a decision on one of these, or the parties reach a settlement on one or all of these various issues as it relate to parenting time, it would take form in the place of a parenting plan. And that parenting plan is a written document. It can be modified, and the standards by which it can be modified in the future of course, are driven by the best interests of the children, but there can also be other legal standards, such as whether or not the children are endangered, that can relate to whether or not that modification in the future is going to take place, and how, if so, it will for purposes of the parenting plan. But for now, hopefully that is helpful information for you as you wade through parenting and divorce here in Colorado. Thanks for listening. Thanks for listening or watching this short lesson on the Divorce at Altitude podcast. If you found this helpful, please leave a review or share with a friend. It does help for others that are going through or thinking about divorce in Colorado. If you want to find out more information, please visit kalamaya.law or divorceataltitude.com, and that's KALAMAYA.law. Remember, this is educational information. It's not intended to be legal advice. Please consult with an attorney about the particulars of your case. We're happy to answer questions. Feel free to give us a call at 970 315 2365.